So greetings and a warm welcome to all attendees of our latest installment in the webinar series, Navigating Ethics Issues in Workers' Compensation. I'm truly delighted to be your host today. My name is John Blake, and I serve as the Director of Sales at Gemini Legal. Before we delve into introductions of our esteemed panelists, I'd like to take a moment to address some important housekeeping matters that'll ensure a smooth and rewarding experience for everyone. First and foremost, it's worth noting that this webinar has been accredited for 1 hour of MCLE credit. To qualify for this credit, we kindly ask that you remain logged in for the duration of the session. Should you have any inquiries or insights you wish to share with our panelists, we've made it convenient for you to do so. Located at the bottom of your screen, you'll find a dedicated Q&A button. Please feel free to type in your questions, and although we may not be able to address all of them, we're committed to addressing as many as possible. Furthermore, for those eager to access resources beyond today's session, I'm thrilled to share that our Gemini Legal YouTube channel is brimming with past webinars, insightful interviews, and engaging podcasts. Our goal is to foster your growth by providing an invaluable educational repository tailored for workers' compensation attorneys across the state. Now, it's with great pleasure that I introduce our distinguished panelists who have graciously joined us today. Each of them brings a wealth of expertise and insights to our discussion, and I'll let each of them introduce themselves, starting with Judge Fedder.
Hi, Judge Feddersen here. And should I give my disclaimer before I introduce myself? Yeah, I probably should. The disclaimer is as follows. The views I express here are mine alone. They're not those of the state of California, its Labor and Workforce Development Agency, Department of Industrial Relations, Division of Workers' Compensation, Workers' Compensation Appeals Board, or any other entity or agency. And they are not to be relied on as legal advice in a specific case. Now that out of the way, I am a judge at the Van Nuys board. Many of you may have seen me or called me, and I'm a graduate of San Diego State University, go Aztecs, as well as Notre Dame Law School, go Irish, and an alum of my own solo practice in Pasadena and Glendale in the 90s and 2000s, and of Shiny and Fargo in the 2000s as a defense attorney. That was a great firm. And Rowan, Gervey and Wynn, a great applicant firm that I was with for nearly a decade. So I became a judge in 2015 in Van Nuys, and I like teaching these kinds of events. I like sharing what I know and learning from other panelists, and I'm sure I will learn a thing or two today.
Thank you, Judge Feddersen. And if I could, I just want to congratulate you on being Judge of the Year at Latino Comp. To give you a little.
Thank you. Thank you. October 7 at the Hotel Indigo. It's going to be a real party.
I'll be there. All right. Kathleen, why don't you go next?
Thank you. Thank you, John, for inviting me. And hello, everybody. And congrats, Judge Feddersen. My name's Kathleen Brundo. I am a defense attorney and a certified specialist. I have been a defense attorney. I hate to say for how long because it's going to age me, but 30 years. Started as an applicant attorney way back when. Knew Jamie way back when. Did 1 year of applicant work, and then for the next 30, I've been doing defense work.
Great, thank you. And go ahead, Jamie.
Well, this is the perfect segue because Kathleen is the causative factor for me getting into comp. How long were you at doing applicants work? 1 year, you said?
For a year.
Yeah, so I was in Barcelona at the time, and she had just left her job, and her employer called me and gave me her job. And so if you aged yourself, you just aged me. I'm 30 years as well. So I took over where she left off. So I've been doing comp my whole adult life, started in 92, actually 93, came back from Barcelona in 93. And have been partners at Glauber Berenson, recently Glauber Berenson Vigo. And yeah, I'm really excited to be here, and well-deserved, Judge Feddersen. Pleasure to be with y'all.
Great. And with these introductions complete, let's not delay any further. Let's dive right into our dialogue. And thank you once again for being a part of this webinar and sharing an hour of your day with us. Your presence here enriches our discussion, and we're excited to engage in an enlightening session ahead. This is approved for 1 hour of ethics credit for MCLE. Somebody asked for that clarification. All right. So going right into it, what are some of the issues you see connected to settlements in workers' comp? Who wants to start with that?
I'll start because I have a commitment to not being verbose. And so I made like little like bullet points of like things that jump out at me. And with settlements, for me, the important things, the ethical considerations around settlements are conveying offers in a timely fashion. Defendants are like, do you have an offer? I strongly believe that I cannot communicate an offer until I have levels of disability reports. So when someone just like out of the blue says, what's your offer? I don't do that. But if you have a demand, if you have an offer, I have an obligation to convey it. One time I had an offer for $950,000. I was young. I wanted it to be $1 million. I told them I needed $1 million and didn't convey it that day. And the adjuster got fired the next day. And the new attorney said that the new adjuster didn't feel the same way and had taken the offer off the table. My client probably would have taken the $950. Luckily, this defense attorney was able to get me the $1 million, but my tushy like I was like, oh my God, like the whole ethical world. I'm like, so thank God that one turned out. That issue, and also the issue of explaining settlements to our clients in a way where they understand how the settlement will potentially impact other benefits, civil claims, Social Security, Medicare, Medi-Cal, yada, yada. So those are the biggest issues that I see in comp around settlements.
I agree with Jamie. As a defense attorney, for us, when we make an offer, we wonder if it gets conveyed sometimes. And I understand the early on in the case and where there are certain issues and potentially there may already be medical by the time I get on a case. But that is very important, and the explanation too. I make sure to put in a CNR an explanation that there might be other benefits affected, so that can also be conveyed. And I think that is very important on both ends.
And I agree with both of you. And I think it's important what Jamie brought up and what Kathy brought up about communicating to the client. That's covered in Rule 1.4 in the Rules of Professional Conduct that was in your course materials here. And something I see as a judge is recently a lot of nominal settlements include some depot fee provisions. And that's fine if there was a deposition and there's a Labor Code 5710 fee that's owed. But if the depot didn't really happen, or it's kind of a manufactured fee, that can really get under the judge's skin. I know Judge Eric Ledger up in Sacramento wrote a scathing opinion about a case where there was a claimed depot fee and no depot, and that was considered a fraud on the court by Judge Ledger. Also, Rules of Professional Conduct Rule 1.8.6 says you shouldn't accept a fee from another party if it's going to interfere with your professional judgment. So for me, that's a red flag if you have a depot fee that maybe looks like the depot didn't happen or exceeds the amount of the fee on the settlement. That makes me really scrutinize the settlement and say what's really going on here. Is it adequate? And when you file CNRs, I've seen a lot of them. I was the walkthrough King and Van Nuys for a few years there. I've probably done over 25,000 CNRs approving.
Oh, wow.
them. And so I could say that most of them are just fine and most attorneys are on the level, but please don't file your job resignations, Civil Code Section 5042 waivers. Don't strike paragraph 3 from the CNR and instead deal with the scope of the injury. And please, proposed orders. I know it's not an ethics issue, but judges appreciate proposed orders these days. If there isn't one, it might go to the bottom of the electronic pile to deal with when we have time.
So I had 2 questions that came up. I'm going to go through them real quick. The first was, must the offer be a complete and authorized offer to require it to be conveyed? Is an offer to recommend with no info on credits an offer that must be conveyed? And the second one was, what if the offer is offensive? So
I'll say if an offer is offensive, I'll tell my secretary to convey it and reject it. Like I'll just say, please, next time you talk to the client, let him know this was the offer and I don't recommend it. And so I sit down with them when it's something meaningful, I sit down. I do need to know the credit issues because credit can wipe it all out. You need to know if there's civil credit issues. Mm-hmm. Otherwise, what are you even communicating? And that's all. Yeah. I mean, that's how I handle them.
All right.
As a defendant, I can't convey an actual offer unless I have authority. So when I convey an offer, I have the authority, and I indicate in my offer if there's any PDAs paid, and any other kind of potential deductions from the settlement. Usually I have the accounting to go with it, so the applicant attorney can talk to the applicant about it. It's much easier to see things physically, even though we're a lot of times in a virtual world, but to have the actual accounting or any credits that you are taking credit for when conveying the offer.
All right, good deal. I'm going to move on. The next question, are there ethics issues that come up in connection with other workers' comp benefits, and what are they?
My notes here, the conflict issues come up for me when I am considering representing more than one dependent in a death case. Also, conflict issues arise for me when I'm representing a home care provider who is providing home care for an injured worker. I do my conflict waivers. I look everybody in the eye. If there's potential conflicts, I do everything in writing that I'm supposed to do, tell them that, they can seek other counsel, the reasons why they might want to. And even if I just don't feel right about it, I will sometimes suggest family members go elsewhere just because it's difficult. And the other ethical issues is just, how work comp plays in with other government benefits or other, civil benefits. And you really do need to, it's a volume practice. You need to take your time when you get to these issues. You got to slow down because these things, there's a letter of the law that we need to follow.
I have nothing to add other than what Jamie said.
Judge?
I would add, from a judge's perspective, there's a lot of talk in the press about worker fraud. I don't see much of it, even in litigated cases. There's employer fraud that doesn't get much press, payroll, misrepresentation, misclassification. Judges, of course, can be reported to the Workers' Compensation Ethics Advisory Committee appointed by the administrative director under Rule 9722 if there's any concern about the judge not being fair and objective about benefits. What's not an ethics issue with benefits to me, but feels like maybe some other judges would disagree with me, is depot fees. A lot of the judges are depot fee police, and they want to say how much the depot fees should be. I'm pretty laissez-faire about that. I expect the defense attorneys to speak up, object, and tell me if the depot fee isn't reasonable. I did do a little math, and I think a $350 an hour fee was considered reasonable 10 years ago. If you adjust that by the SAW rates since 2013, it would now be $598.05, so about $600. And I think the bar maybe isn't up to a $600 an hour depot fee yet. But if you look at the SAW rates, based on inflation and what's happening to wages, it's justifiable. So defendants, if you feel differently, put it in writing, speak up, and I'll respect your objections. But there's a lot of talk about depot fees like it's an ethics issue. I don't consider it one. I consider it something negotiable between defense and applicant.
And we usually do. And if we do object, if there's a petition filed, we will file an objection if necessary. But usually we just work it out between the parties.
As you should. That's the way to do it.
Yeah.
All right, good deal. And then next question, do you see any issues where it comes to hearing reps in workers' comp?
I mean, I'll kind of punt to you guys because I don't see any. For those people out there, y'all who knew Jerry Wonke, he was a hearing rep and he was the best representative, one of the best representatives I've ever met of an injured worker. And I have had many attorneys come through that were not as good as him. So as long as the person is competent and there's oversight, I don't know what you guys see out there, but I know a lot of hearing reps who are as good, if not better, than a lot of the attorneys I meet.
Me too. And I've worked with some. I haven't come across any issues.
I agree. Most hearing reps are competent. Just read Rule 10401 of the regs, and it tells you they're held to the same standard as attorneys, and most of them live up to it. Let's face it, they're bad attorneys and great hearing reps.
True. Okay. Great. And then next question, technology and data privacy are all over the news. Are there ethical concerns that any of you have dealt with regarding either of these?
I'll be quick, so
Yeah,
I'll start.
Go ahead.
In terms of, yes, we need to have firewalls. Some of our clients, as a defense attorney, we have to make sure that there's no breaches. We have to have certain levels of security on our computer. So there are requirements from an ethical standpoint that you have a safe system that people can't access it, that don't have a right to access it, because obviously in the virtual world, there's a lot of documentation in our systems, including medical reports, social security numbers, and all of that has to be firewalled. And you need to be very careful in how you run your IT systems and watch out for hacks and suspicious emails. And I'm going to let Jamie take it from there since she has some experience.
Well, let me say something too, because I want to get out of Jamie's way too, because she's got the real straight story for us here. I just want to say that the DIR Information Security Office sends judges an email practically every week saying some firm's been hacked. So it's out there in force. And Jamie, if you could tell us about what you know about that.
So yeah, I got hacked in May. I was literally living in the Matrix. Like it was an out-of-body experience because it was fascinating. The reason why it was fascinating and not, career ending, not career ending, but office ending. I had insurance. So insurance, get cyber insurance. We had it and it made all the difference. So the second we got hacked, my CFO or my COO contacted the insurance provider, Chubb. We had Chubb. They gave us a panel of attorneys to choose from. I called the first attorney. It was the most impressive group of humans. I mean, really everything right about lawyers. By 5 o'clock that afternoon, I had a team of 28 people who we would get on a call every day at 3:30 because some were in India, some were my attorneys were in Pennsylvania. This one, they were all over the world. We lost you. We met every day at 5 for 6 weeks. I had an attorney team. I had forensic investigators who were dealing with the FBI. Within those forensic investigators, there was separate team members. One's job was to collect the information and give it to the FBI and find out, where the hacking was coming from, piece of information. Everyone's like, oh, I was hacked by Russians. The reality is that you can get hacked by your own IT guy or someone who works, or some guy, not even your IT guy. You might love your IT guy, but your IT guy hired some guy, and that guy can get the information and they filter it through some sort of program or agency or yada, yada, so that it is coming from Russia, so that you're scared, because who's like, oh, I got hacked by the kid down the street. No one's going to cough up $1 million. But when you hear Russians, they know that Americans get scared historically. And so it can be your own guy who can get in there and then filter it through the Russians. So they collected information. They had to protect us. We had to download things. We had to back up. Then I had a ransom negotiating team. So another piece of information, insurance cannot cover if you choose to pay the ransom, because insurance companies cannot negotiate with terrorists. So no matter what, you have to decide yourself if you're paying that ransom or not. Luckily, I did not. For me, my client's information is in a web-based product. It's in Maris. So they were never able to get to my client's information, and business was as usual for me at all times. For those of y'all who aren't in a web-based program, if you were to get hacked, your business would stop. And I feel for you. Because then the next ethical consideration is, you got to tell, who do you got to tell, and how fast do you got to tell it, and how much do you have to tell?
Yep.
I mean, some of us, our reputations are dependent upon people trusting us. And if they think they've been hacked, or you've been hacked, I mean, a lot of these hackers are trying to get into like hospitals and things like that, or law firms, where if you felt you got hacked, you would no longer want to do business with that person or that entity. That's why you're going to pay those ridiculous ransoms. Ultimately, so here's a question. I'm not going to tell you what I did. I'm going to ask Your Honor what you think I should have done. If you're not frozen, are you there?
You're frozen.
The hackers got me, Jamie. As soon as you launched into my story, my computer restarted.
Could you imagine?
I don't know what it is.
I swear it was like that. I swear it was.
Don't want you to know.
Yeah, like you literally start to think, oh my God, are they following me? So, so the only thing they got my financials. They got like the business side of my business, which, I just told my people, like, just, start putting it together. Like, you just want to back up things, but all they had was my actual GBV held hostage, not my client's information. Some of the individuals in my office, their computers, their hard drives were compromised. And on some of those drives, there were IMR denials, IMR, upholds or whatever.
Yep.
So at the end, the attorneys said, would you consider that protected information for which, a HIPAA violation occurred? Kathleen, do you think if I had my file walking around in court and I dropped an IMR uphold, that I potentially, like, there's a HIPAA violation?
So I think there you have to look at it in a couple different ways. One, it is somebody's health insurance, but at the same time, it's also served on people involved in the litigation and potentially filed with the WCAB. Mm-hmm. So I would assume that there is a level, and the judge might be able to better address it. There might be a level of you dropped it and picked it up, someone handed it back to you, probably not a violation.
There's not a social security number on there?
There isn't. Nope, I agree with that.
Your Honor, can you hear us? What do you think?
Yeah, I can hear you just fine. I don't know if my video's frozen, but I heard you.
It's a good picture, so you're fine.
Okay, yeah, at least I'm not making a derpy face. My eyes aren't closed. That was a bit of
no, it's really good.
So the HIPAA violations are outside my jurisdiction. I don't really act on that. So I think that's up to the firms and to the government to try to protect personally identifiable information and do the best we can with that. So I personally would not be, sanctioning or penalizing anyone if there was some kind of a breach of private information security, especially if it comes from third parties like hackers.
Well, and then the other information that was interesting, because I chose not to negotiate, and they told me that I might get a call from a husband and wife team from Russia. Like, literally, these hackers, they have this like not Rocky and Bullwinkle, Natasha, what was their name?
Natasha.
There's some husband and wife team that now call you and start to like engage you in a conversation, but I never got that call. I didn't negotiate and nothing came of it. I think I mean, the last thing I would say for firms, especially defense firms, is that, once you're hacked, I don't know what you're supposed to do. I mean, I would probably go straight to the adjuster's, desk and ask for the photocopied file. I'd get my calendar and I'd go through all my cases and I would go meet the adjuster and try and put together as much as I needed, whether it be PD reports and what I needed on a pretrial conference statement, so that there was no delay as a result of these issues.
I think that if you unfortunately have no access to documentation, you have to request copies. I mean, whether it's from defense counsel or if defendant's not represented from the claims adjuster directly. I mean, in order for you to continue to operate, I think that's the best thing you can do to try to rebuild your system if you don't have access to anything, which is for everybody out there why Jamie's right. It's key to have cyber insurance. It's key to have firewalls. It's key to have all of your computer systems. You can't say hack proof because anything is possible and anything could happen. But to the extent that you can protect yourselves, you should take all steps to do it. And some of our clients do request that we have certain mechanisms in place. So don't just hook up and willy-nilly go without cyber insurance or without some kind of firewall or protection. And please look at the emails before you open and click on any attachment. Just as a little side note, you can click on the name of the person who sent you the email, and if it is a funny, like Joe Bot or something, anything that's not sounds right, don't call the number in the email. Call the person whose number you have, because obviously phone lines can be doctored as well. And check before you click on any attachment.
Great advice. And so, Jamie, I did have a couple of quick questions. One of them was, would you mind sharing the name of the insurance company that you use for cyber insurance? And they were wondering, is it expensive? What's the cost on it? So, Chubb.
No, I don't think it was expensive.
Okay.
I don't remember the exact quote, but it certainly wasn't expensive.
All right. And we do have quite a few questions. I'm going to hold off on asking questions because we have a lot to go through, and I'll email the panelists and try to email back to anybody we don't get your question to. Okay. So I'm going to move on to the next one. And so what do law firms have to watch out for in vendor relationships? And on a kind of a side note that I've kind of seen, if your staff is getting some type of kickback and the attorney doesn't know about it, are they still in jeopardy of an ethics violation? Who wants to grab that?
Let me address that. I know that with SB 863, they added that section to the Labor Code 139.32 that was designed to crack down on any kind of mutually beneficial relationship of referrals, and it conceivably could attach to any kind of vendor. It says that except as otherwise permitted by law, it is unlawful for an interested party to refer a person for services provided by another entity if the other entity will be paid for those services pursuant to the workers' compensation reimbursement system, and the interested party has a financial interest in the other entity. And financial interest means any ownership, compensation, or it can mean a cross-referral arrangement, whatever that means. So you have to be really cautious these days about the relationship between vendors and attorneys, doctors and attorneys. I mean, it's always been something to be careful about, but especially after the reforms of SB 863, it's good to make sure everything is being done at arm's length and isn't like a system of swapping referrals or I give you this for that.
Great.
Yeah, I mean, it's err on the side of overly conservative on everything. I mean, like one of the things when it comes to vouchers, we give a list. We have a letter that gives a list, and we specifically say that we don't recommend one over the other. And we also say, if, beware that some, services are not necessarily on the up and up. And if you experience anything, please report it. I think, it is incumbent on us to, I don't want to use the word whistleblow, but I think that elevating our practice, the onus is on us to, right the wrongs so that we can, continue to be proud of what we do.
Agree. As a defendant, and I can only speak for myself and my firm, we don't get to choose the vendors. Our clients tell us which vendors they use. So, but I agree with both the judge and Jamie. Always err on the side of caution. So we don't have we don't get any kind of choices, at least the clients I deal with.
Yep. All right, good deal. What are some issues that firms have to deal with regarding following regulations? I know one that we fight with is the 30-day hold, for example, and making sure firms follow that when many don't find it necessary. So, Judge, did you have an opinion on this?
Oh, definitely. The reg you're referring to is section 9982, subsection D, which says there will be no payment for copy and related services that are provided within 30 days of a written request by an injured worker or his or her authorized representative. And so for the copy service, I think it's incumbent on you to get a copy of that written request. And if there hasn't been a written request at all, that could also be, I think, a way of defendants not to pay. The best practice, and all applicant attorneys should do this to take care of their copy services and vendors that help them out with discovery, is to make that written demand for documents, make sure it tracks what's going to be on a subpoena ducis tecum, and provide that to the copy service. The copy service knows that after 30 days of the date of that letter, it's safe to get the records, and there isn't going to be a 9982D defense not to pay for them.
I mean, I agree. You should wait. I mean, another ethical consideration that comes up around like taking care of your vendors. So regs, following regs, vendors. Ethically, as an applicant's attorney, I really appreciate the doctors who continue to practice. I mean, we've been doing it long enough, Kathleen and I. We remember back in the day. I'm like, what did we complain about back then? And by the way, we would complain like, oh my God, the sky is falling. And the sky was so blue back then. But taking care of the doctors, to me, I feel like we all owe an obligation to the doctors who are doing the good work to make sure that they get paid. I mean, obviously, if they're doing it right, then they deserve to get paid and they shouldn't have to fight and wait years to get it done. That's another thing with settlements that reminds me, because sometimes I'll see language that is put in the CNR and I know full well that it's put there to try and defeat the lien. There are times when people ask me to dismiss things, and sometimes that's in my client's best interest. So all I will say to the defendant before I sign this, will you please negotiate the lien? I want you to negotiate the lien before, not after. I also tell all my vendors that they can list me as a witness on any lien and that I would show up in person if need be to testify as to why I sent it to them on the day I did, because we try to think everything through and make sure that, we went down that path for a reason and we papered it up. So that's my
agree. I know that a lot of times you end up with liens just based upon fee schedule review versus usual and customary and the arguments there. But for me, I like to have a clean CNR as well. I'd rather try to negotiate everything. Sometimes it's just not possible, except for EDD. Always try to negotiate them before submission of the CNR. But to actually make a good faith attempt to resolve, because if you can get a case closed quicker, and then the liens can keep a case open for months or even longer. So it behooves you to put what's best for your client, to do what's best for your client and get that case closed and negotiate those liens.
And since we're talking about rules, I need to make a pitch here about rules 10400 and 10401, as recently amended, effective January 1, 2022. Email addresses should be in every rep notice for an attorney or non-attorney. And that's a source of frustration to myself and probably other judges too, when we see rep notices that don't have the email address, because our secretaries want to email you copies of the orders you've requested as quickly as possible. And we can't do that if we don't have an email address. Then we're stuck with snail mail.
Good point, Your Honor.
Great, thank you. Okay, cool. So are there any issues where what you owe to a client might be in conflict with what is right for your staff or financially? And we talked about a little bit about this.
Remind me why I don't remember why we thought that was interesting. Remind me. I remember.
I could step in. I remember we were talking about it, and I interpret this question as meaning conflict of interest between the fiduciary duty of attorneys to put their client's interests first and the client's interest as a fee-paying individual or entity. And I think that every firm, small or large, has these conflicts. For the defense attorney, it's a conflict between the defense attorney wanting to bill as many hours as possible. I was one, I remember that. and the client wanting to pay for as few hours as possible and close the file. For the applicant attorney, it's the conflict between the client wanting to spend as much time as possible, being reassured everything's okay and everything's explained, and the applicant attorney wanting to spend as little time as necessary to maximize results for the client and get a fee on it. So there, and plus depot fees, the applicants aren't fans of giving their testimony and they would like it to be over with quickly, but the applicant attorney, let's face it, gets a fee for it. So there might be an incentive to allow the depot and let it go on for a while to collect that fee. So I see this question as asking, where is there a conflict between the duty that you owe to your client, the fiduciary duty, versus the need to run a firm where, let's face it, for defendants, they're selling their time for a fee. For applicants, their time's a premium, and they want the fee without spending time. And that creates conflicts. But good attorneys balance that. They put their clients first, and they still manage to pay the bills somehow.
I agree. The client's interests come first. And in all honesty, when you settle a case quickly and you do it well, you're rewarded with more work. So whether you close a file in 3 days, 6 months, or unfortunately with catastrophic injuries, they tend to be open much longer. But your duty, your ethical duty is to the client. The client wants the cases closed because unlike a fine wine, they don't get better with age. And we see that every day, amendment. So your duty is to the client and not to your pocketbook.
And I agree. We've always, the reason came to comp because of Kathleen, I stayed in comp because I really liked the way my now retired partner, Russell Glauber, looked at things. And he said, get them in, get them out, get them back to work. These are workers. These aren't people sitting around waiting for ads on TV. These are people who got hurt at work and just get them back to work. He's like, and then he would say, they'll get hurt again and they'll come back. But that part, they do. But you just think, if you just think about the client every time, it all turns out. And then, 10,000 hours later, you're a master at what you do and you pay your bills easily because your reputation speaks volumes. And really, for applicants, attorneys, it's really tough, dealing with the applicants because you have empathy and sympathy for what they're dealing with. But if you sat around and did that, talked to them and made them feel good all day, you would not be biting and kicking and scratching like we need to. So you just have to have a come to Jesus or Moses conversation with them and look them in the eye and say, just because I don't talk to you doesn't mean I'm not working my tush off, and I will contact you, and give them alternative means to communicate. Have them write it in a journal and send it to you, or email your assistant who can just so that they can and then schedule a meeting to talk with them. We schedule a conversation every 30 to 45 days. And I say, keep your questions for that day. And then I will make a date with that person to talk to them for a brief period of time to talk about their case. And I will address all their questions. So that's
I think it's a great practice, actually.
Yeah.
All right. So are there any issues you see in getting help from, and I see this happening more and more, outside of the firm, either onshore or offshore, yet either as employees or the firm, employees of the firm, or outsourcing?
We don't use contract attorneys. We don't outsource. I'm old school. We socialize, we do Vegas, we go to the Dodger game. I just can't imagine a Christmas party with a bunch of computers around the edge. Like, hey, go say hi to Hummin' over there. I believe this is a tough practice. Having a team of wonderful people around you makes it easier. And so really knowing the people and having a connection with the people is important to me. But I know other people do it, and I'm sure that they're probably lucrative decisions. I just don't experience those issues because I don't do it.
Yeah, it's there's no contract attorneys. The attorneys that I work with are here, whether they come into the office or they work remote. And they obviously have to be licensed in California. You can live technically live anywhere, but everybody lives in California. So.
Yeah, Your Honor.
Well, judges don't outsource except for carve-out ADR programs and arbitrators, I guess. But I would say if I were in business today, I would consider outsourcing tasks as long as it's disclosed to the client, the work is supervised, steps are taken to protect client data, and of course, abide by the duties that regard associating with other attorneys or outside non-attorneys addressed in Chapter 5 of the California Rules of Professional Conduct. As long as you're following the rules, supervising, being careful, I don't see why you can't outsource.
I do think too, if you have a question that's on a potential issue that's not related to your field. So if there's a potential third party case or you have questions or issues, obviously I would recommend you go outside your firm if you don't have an internal attorney practicing that kind of law to gather information and become as knowledgeable on an issue as you can. That person obviously would not be employed with you.
Right. No, that makes sense. Okay, great. And are there any other pitfalls or common issues that attorneys fail to recognize, and how do you navigate those while still building a growing practice?
Well, I'd say comp is a volume practice. That shouldn't be an excuse for it being a sloppy practice. So you need to have the people. You shouldn't, we just experienced, my partner just was in a horrific car accident. And we all rallied around. Like we were all just, making sure that our clients never felt a delay as a result. So having a team or contract, whatever you got to do to make sure that your client doesn't experience a delay or denial because your business practice, your business model.
Exactly. Things change every day. You have to be able to roll with the changes or the punches, however they come. And you have to make adjustments to make sure the clients aren't neglected or suffer or feel like they're being neglected or their cases are being neglected. With the virtual world, there's changes every day in terms of just look at what Chat GBT has done. So you have to adjust, and ethically you have to adjust. You cannot use something that you didn't produce. That's not yours. It's just, research is one thing. If you're doing a trial brief or you're looking up case law, you can do research. It's easy. Everything is online. But the way the world is going, there's changes every day, and you have to make adjustments and changes to your system and your practices as that happens. You have to be able to roll with the punches.
Your Honor, anything you'd add?
Yeah, I'd add to that just in general, don't cut corners. Know the law, know your file, take care of your client, take care of your own physical and mental health, and don't try to do too many things at once. A lot of people are juggling multiple phone trials at once. That's got to be stressful. You'd have to burn out quickly on that, and the judges get frustrated with it too. I think in every interaction, protect your reputation. We have a tight-knit community, so it's important for attorneys to remember that they're probably going to see their opponents again on another case, and they're going to certainly see the judge again at some point if they're practicing in work comp law. So it's a pitfall often for parties to burn bridges because they get a little worked up about an issue, and it's important not to do that, to see the big picture, to remember the duty of candor to the court and the duty of maintaining a professional demeanor. It's especially for judges, but for attorneys too, maintain a professional demeanor because everybody knows everybody, and you will have to deal with the same people in the future.
I think that's one of the best things about comp is that you do deal with the same people over and over, and judges. And the bottom line is you're only as good as your word. So if your word's not good, you're not going to survive in this business, regardless of which side you're on.
exactly what I was going to say. 99% of the people are good by saying, that some people get a bad reputation. I'm not talking about the vast majority of people.
Right.
I would say, I mean, one of the things that I know we talked about in preparation for the call was because our community is so tight knit and we'll see each other over and over again, and professional courtesy. I mean, you want to extend professional courtesy, but we've all agreed here that our client has to be our number one consideration. So how do you allow for conflicts, calendar conflicts, while nurturing those relationships? And one of the things I do is when someone tells me that they have an issue on the day of the hearing, I offer to meet any time or day before then to handle it. So I will go out, jump through hoops to go to court. I mean, luckily I live literally 4 minutes away. So I'm like, I'll go to court. I'll do this. I'll do that. We can jump on the judge's line. I mean, people don't think that like you got a trial in a month. That judge is going to be on his conference call or conference line at 1:30 or 8:30. So I just agree, like, let's just jump on tomorrow at 8:30 and ask the judge and just really bend over backwards to help that person, but not let the case, get continued as a result.
So for the defense side, most of our clients expect the handling attorney to make the appearance. If you cannot make the appearance, we notify the client and advise them in advance because nobody likes surprises. Also, we do try to extend professional courtesy, but again, we want our clients to be aware of what's going on and advise them before anything happens. So, and
Like
you will
Kathleen,
deal
in a
with
case,
yeah.
If one of your clients said you have to handle it, and we have an MSC next week, and you're having, a family issue. If you and I did the pretrial conference statement right now, we tried to settle it, you didn't, and we called into Judge Feddersen this morning and said, we have an issue. We're going to upload the pretrial conference today. Do you mind if Miss Berenson, and so that you're the only one handling it.
Right.
And of course the judge would say, I mean, obviously we're not showing up that day to say, hey, guess what? Is this okay? We're getting out in front of it and your client's getting served, my client's getting served, and we're still,
Exactly. And that's the whole point is you can figure out something to do, and whether you do it before, I like to do it before. If I know an issue is coming up now, sometimes obviously you can't. There's always an emergency, but usually if you have a conflict, reach out beforehand and get it taken care of. It's not difficult to do.
Don't wait till the last minute. I mean, that
No.
even with my attorneys, like they're like, oh, I'm on vacation. If I look when my hearing comes in, I clear it, or the second there's some emergency, I get on my calendar because I never want anyone to deal with it the day before or even a week before.
Right. And notices come in and you have the ability to say, oh man, I already have a trial scheduled. So let me reach out to applicant attorney now. So
and reaching out now versus reaching out the week
Yes.
before is a big difference.
Yes.
Yep.
And it really does.
That's in the regs now. 10759B now says parties have to meet and confer before an MSC. So everyone should be aware of that.
Yeah, meeting conferring is so huge.
It is.
I mean, it makes all the difference, I believe. I have a question. Do you think someone has an obligation to give their cell phone out? In this day and age where we're all online, I mean, so if a judge isn't there that day, like sometimes you're like, oh, your file's been transferred to another judge's line. You want to be able to text your opponent and say, hey, we're over on Judge Hamana's line. Don't you think in this cyber age that cell phones are, I mean, you should be able to deal with someone via their cell phone.
I agree. And I haven't had a problem with anybody giving out their cell phone. There may be an issue with respect to text because you can't save them. I mean, they're in your phone and there may be an issue there. Calling one thing, but I always say confirm via email because it goes right into our paperless system and it is easier to follow and keep track of. But yes, you should give out your cell phone number. And if I do get a text, then I will send a confirming email. And that's the other thing too, is when we get a referral or I get a referral in-house and the applicant's attorney's email is not anywhere on there, or their generic email, you look them up on the state bar and it says no email, no fax, no. I don't understand that either, especially in today's day and age. Look, we all have to deal with, service of documents and everything else. And if you don't have a generic email box for service, you should give out your email. I don't understand why it's so difficult to get.
There's no rule to enforce giving out a cell phone number on a conference line, but every party does have to provide a telephone number with the notice of representation. And I think that it's reasonable to expect some means of communication. If anyone's circumspect about giving out a cell phone number on a conference line when asked, you could, I think, reasonably give an email address if you're there ready to respond to an email, or an office number. And just so you know, the conference lines do maintain a record of everyone who called. So if you are concerned about who's on the conference line, every judge at the end of the day gets an Excel spreadsheet with every number that called into the conference line, the time they were on the conference line. So if anyone did anything especially creepy, you could track down who was there.
Wow, that's good to know. Didn't know that.
Yeah.
Yeah, I was on a call yesterday and the applicant attorney didn't appear. And so the judge asked me to call. So I only had the direct line and it goes right to a service. It's not anybody. Well, we'll relay the message. Well, nobody ever called me back. And I called back in. I told the judge I couldn't get anybody. I had to leave a message. So can we just, he goes, I'll just give you a continuance, because it was a priority conference and we were still in the discovery phase. But that's kind of frustrating too, when you call and you don't actually get the firm or someone at the firm, or,
Yeah.
Yeah, that is frustrating, and it delays things. John, do we have any time for questions that have been rolling in?
We do have a couple of minutes for questions. I had a few of them here. One is on depot fees. So the question was, what rate is Jamie charging and how much is Kathleen recommending? I thought that was interesting.
You know what?
If you want to share.
I've seen lately everything from 400 to 500, and I have and everything in between. So I think it just depends. My clients pay $450. I even have had someone who's been practicing for a very long time pay 500 or request 500, and I recommended that. Based on the years of practice. I haven't seen anything above that. So
we bill between 500 and 600. Although I did bill myself out at 1,000.
Jamie.
I just did.
Jamie, I'm not going to pay that. My client's not going to pay that.
By the way, I hadn't done a depot in a long time, and it's the case. I'm like, bill it 1,000. They're like, what? I'm like, just bill it. I feel good about that. And we don't know what happened with that one yet. But I was like, no, I think I'm worth that. Sorry.
There you go.
I can back that up. We'll see what happens.
Well, there are experienced civil attorneys that I would say that in the civil world, if you were an experienced civil practitioner, you get 1,000. It's just in work comp.
For sure.
But like I mentioned before, based on the state average weekly wage increases, there's a very plausible argument that 600 is what the top of the scale should be today. Based on what we thought was the top of the scale 10 years ago. Now, you have to be practical. On the other hand, if the defendants aren't going to voluntarily pay you that 600 an hour, then it makes sense to be willing to compromise, because litigation has its own cost too.
It does.
Sure.
That segues into one of the questions here, because I saw someone asked if the insurance wouldn't pay the ransom, what did they help cover? It was about $100,000 in support that they gave me for 6 weeks, because we did meet. So the attorney's fees, were amazing, and they had a huge bill. Then there was those forensic people. I had a team literally around me, helping me every step of the way and anteing up my protection so that hopefully I'm reducing the risk of having it happen again. So and then at the end, we all decided with their counsel that I wasn't going to pay. And the insurance does have a caveat. It said they don't say you got to pay it. So that's the thing, because insurance companies can't pay terrorists. You pay the terrorist, and then we will review it. So I never got there. So I'm not saying they won't pay. Well, they won't pay directly the ransom. You got to pay the ransom, and then they will discuss after you pay it how much or if any. So that, the fine print scared me, but I didn't have to.
I'm going to ask one more question about depots. Is it unethical for a defense attorney to object to an applicant attorney writing to a doctor prior to the deposition, setting forth the legal theories and issues to be discussed at deposition? We often have defense attorneys objecting to our issue letters to doctors.
Before a doctor depot?
Yeah, so we're talking about QMEs and AMEs here, I assume, and I would direct that person to read the in-bank decisions in Maxim regarding AMEs and Suon regarding QMEs, and when a letter might contain information such that it should be sent to opposing counsels first before being presented to a doctor. So treat it like any other interrogatory, comply with 4062.3 if you're communicating with a QME or an AME. Those are the rules. If you're deposing a treating physician, then I don't think there's really any rule. You just can write to them.
Great. Thank you, Ron. So with that, I'm going to go ahead and thank the panelists for joining, and also thanking all the attendees. I hope you found this very helpful. Again, you can find all of our past webinars on our YouTube channel, and you'll also get an email in about a week having to do with your MCLE certification, and also with a link to the recording on the YouTube channel for this one, for anybody that wants it. For anybody that put in questions and we didn't get to them, I'm going to try to email the panelists and see if we can get answers to your questions and get back to you. And again, thank you everybody for joining, and I hope you have a great day.
Bye. Thank you.
Bye.
Thank you.